Hello guys, and welcome to another episode of my lecture. This is Olayeni Kolola Daniels, popularly known as Dieko Spectre, and this is another episode of Dieko Talks Law. On today's episode, we'll be talking about the law of equity, particularly how to identify equitable interest in relation to purchase of land. Do note that this particular lecture is not restricted to the law of equity alone, because it is impossible to understand the sale of land under land law without understanding this equitable principle, which we will find both in common law and under customary law. We will be investigating the common law and the customary law in relation to the equitable doctrine when it comes to equitable interest. Do you understand that? Now, when you are talking about this, it is very important that you have a basic knowledge of land law to be able to continue. Even if you don't have that basic knowledge, this lecture is going to give you as much knowledge as you would need to be able to understand that. But before we go into the crux of what we are talking about today, which is the equitable interest and how it relates to the purchase of land, identifying equitable interest. If this is your first time of coming to my channel, then I want to say a very big welcome. Please make sure that you click the subscribe button and make sure that you click the notification bell so that anytime I release a video of this nature, you are going to be one of the first set of people to watch that particular video. Also note that this particular class was made possible through the effort of different people, one of which is Komolafe Praise, a University of Ilorin student who helped with typing the note, and Odunwole Emmanuel, who is the head of media in relation to the Dieko Daniels School of Law. And I want to say a very big shout out to the both of them. Now, while I continue to the crux of what we are talking about today, talking about equitable interest, talking about sale of land, purchase of land, and stuff like that, it is very pertinent for you, if this is your first time of coming to my channel, to note that there are different videos that I've made on law of equity. For example, when it comes to the 12 maxims of equity, I have videos on all of them, making sure that you have a concrete knowledge on the law of equity. Also, when it comes to the doctrine of notice, I have video of all of them as well, so that you will understand the difference between actual notice, imputed notice, and constructive notice. Those kinds of notices would be obvious, are very important, in your discussion and your knowledge of the law of equity. So while we are talking about the purchase of land today and how it relates to equitable interest, I think it's pertinent for us to get straight to our note. So what we are talking about is estate contract under the common law. Same thing as the purchase of land under the common law. That is English law in particular. Please note that this particular segment on identifying equitable interest in relation to purchase of land is divided into three categories. We have the part 1, where we talk about the common law and how the common law sees equitable interest in relation to purchase of land. We have the part 2, which talks about the customary law, where we look at the case of Ogubambi versus Abowaba. Also, we'll look at the case of Olowu versus Oshinubi when we are talking about customary law and how they treat equitable interest in relation to purchase of land. But that is something we are going to be discussing in the part 2 of this lecture. And then we have a part 3 where we'll be talking about a continuation of the part 2. That's the Nigerian perspective, the customary law perspective in relation to these purchase of land and equitable interest, where we'll be interrogating the case of Orosomi versus Idowu. So these are the three cases in relation to purchase of land in Nigeria in relation to equitable interest that is very important for you to know. But before we talk about the Nigerian perspective, I think it's quite pertinent that we talk about the English perspective, which is the starting point of today's lecture, the English perspective. Estate contract are agreements for the purchase or lease of land. If the vendor or lessor, now do note that when we are talking about purchase of land, the person is the what? Is the vendor. That means that the person is selling the land to the other party, right? That's the buyer. Now, when we are talking about leasing of land, leasing is different from purchase, because when we are talking about leasing of land, we are saying that, oh, I am not giving you all my interest on this land. I'm only giving you the interest for 1 year. Okay, I want you to rent my house for 1 year, 2 years, 3 years, whatever number of years. So far, it's not the total number of years that I have interest on that land. You can take that particular portion. That doesn't make me a vendor, because when you say vendor, I am a seller. It makes me a lessor, because then I am leasing my interest to that land to you. Do you understand that? So if the vendor or lessor broke the agreement, do note that in the first sentence, we talked about an agreement for sale or an agreement for lease. We did not say that there was any writing. Do not forget that the first standpoint in land law, according to the statute of fraud, it says that when you are conveying or giving someone else your interest, it must be in writing. It will not have the force of law except that contract is in writing. Do not forget that. So having that at the back of our mind, in this case, there was an agreement, merely an agreement. There was no contract in writing. So now we are saying that if the vendor or lessor broke the agreement, do note that the common law will not give power where there is no written agreement, right? But now, where there is an oral agreement and the vendor broke the agreement by failing to convey or lease the property to the purchaser or lessee, at the common law, the purchaser's or lessee's only remedy was damages for breach of contract. Now, let me explain to you what that means. Now, we are saying that there is an agreement, right? There is an agreement to sell land from Mr. A to Mr. B. Now, Mr. A then decided not to sell the land to Mr. B. What can Mr. B do? Since there was an agreement to sell the land, doesn't that mean that Mr. B has some form of interest on the land? The answer is no, if we are talking about the common law perspective. Mr. B doesn't have any interest on that land. All Mr. B has is a remedy in relation to breach of contract when it comes to the common law. In relation to that land, Mr. B has no interest whatsoever. That should be at the back of your mind. Do you understand? However, equity, what did equity do? Equity, however, in such circumstances, grant a decree of specific performance, which compelled the vendor or lessor to execute the conveyance or lease. Do you see that? At common law, we are saying, hey, hold up. This your agreement, we do not recognize it here, so much so that we are going to confer you with any right on that land. So when it comes to the agreements that you have made between Mr. A and yourself, in this case, it does to concern us for common law. Do you understand? When it comes to the agreement in relation to your interest, it no concerns us. What concerns us is that, oh, Mr. A has breached that agreement. It is the breach of agreement that we are concerned with at common law. At common law, we do not even recognize that you have any interest on that land. Whatever you have is no interest at all. For you to have an interest under the common law, it must be in writing. Where you fail to have it in writing, my dear, sorry about that. But, well, you can still come to us, though, at common law, that there has been a breach of contract. There you can have a remedy. But you will never have a remedy in relation to land law. However, equity said, no, that is injustice. That is not right. That is not fair. You know, there was an agreement that he was going to convey the land. So, why then are we treating the agreement like it never existed? Just imagine that somebody decided that he wants to buy a house, and then he called his friend. My friend, you have houses all around. I want to buy this particular house. And over the phone, they made the agreement. Okay, you want to buy the house, Abi? No problem. I'm going to transfer money to you. That's the buyer talking. I'm going to transfer money to you. And he transferred 5 million naira to the seller. And then the person, because he had transferred the 5 million naira, he said, yes, I'm now a landowner. He started making deals like he was a landowner because he knew that he obviously should be a landowner, and, you know, all those kind of things. Then 2 years down the line, when, you know, he now wants to, you know, make use of his property and all that, and now say, yeah, I want to use my property and all those kind of things. And then the vendor now say, well, why are we welling? Don't let us well. Where is my land? and then he goes to court and say, my lord, come and see, oh, come and see, I transferred money, oh, see receipt of transfer, see this, see that. My lord will now say, oh no, regardless of the fact that you transferred money, the land is not yours. Isn't that unfair? Isn't that unjust? And that's what equity says. They say, no, that is very unfair and that is very unjust. So therefore, equity then said, you know what, where there is an agreement of such nature, even though it's not in writing, we are going to grant what, a decree of specific performance, which will compel what, the vendor to execute that lease if it was a lease, or to execute the conveyance if it was a sale. Do you understand that? Now, to continue with my notes, in equity, as soon as the contract of sale or lease comes into existence, that's the oral contract, the purchaser acquires an equitable interest in the property. Such interest is valid against all except a bona fide purchaser for value of the legal estate without notice of the equitable interest. Now, do you see that? Do you see what I was saying? The moment there is offer from the buyer and there is acceptance from the seller, or there is offer from the seller and there is acceptance from the buyer, you know what happens in common law? The common law will say, as at that point, there is still no interest that have been conveyed or anything. But equity will say, the moment there is acceptance and the promisee has furnished consideration, because consideration must move from the promisee. The moment the promisee has furnished consideration, then the buyer has what? Has equitable interest. Do you see that? The moment there is the existence of offer, acceptance, consideration, which is supposed to make what? A valid contract. So far other things are present, that is the intention to enter legal relations and the rest. So far those things are there. What does that give us? It gives us an equitable interest given to the buyer. The buyer has equitable interest. That is what this is telling us. Also, it's important for you to note that although B has equitable interest, the only person that can defeat B interest is who? Is a bona fide purchaser. That is somebody who purchased the property bona fide, legally, through conveyancing, where there must have been a deed of assignment. Do you understand that? There must have been a deed executed, written. It is only that person that can defeat B's interest. Don't forget that B is the one that paid money to A. Now, B paid money to A in 2015, but another person paid money to that same A in 2017. Not just that, that person now executed a legal document in relation to that purchase. Not just that, the person did not even have notice of B's interest. That is the only person that can defeat B's interest in court. That is the only person that can defeat B's interest. So when we go to the next part of the note, it says, for example, if A, having agreed to sell to B, then sells and conveys property to C. Are you seeing that? He agreed that he will sell to what? To B. Then he did what? He sold to C. What did C do? C, who has no notice of B's equitable interest. B's equitable interest will be defeated, and he would no longer be able to obtain what? Specific performance for the agreement. He would have to what? Fall back upon his common law remedy of what? Of remedy of damages against A. Now, C will of course obtain a good title. Now, on the other hand, if C had notice of the vendor's agreement with B, when he, that is C, purchased the property, B's equitable interest will prevail and C would acquire no title. Can you see that? The only time B's equitable interest in that land will be defeated is when what? Is when C purchased the property under two conditions in common law. Under two conditions. Condition number one, C must have gotten that property through what? Bona fide purchase for value. Bona fide purchase for value. He must have paid for value. He must have paid for value, and not just that, he must have gone through the legal procedure. If he went through equitable procedure, do not forget the equitable maxim that says where the equities equate, what's going to happen? The first in time shall prevail. So if C's interest is only but equitable interest, then the first in time B must prevail. But since C is legal, because it's bona fide purchase for value, it gives C what? Legal. Also because it's a legal interest that was gotten through conveyancing, through a deed, must be in writing. Because of that, and also condition number 2, because he had no notice of B's interest. Condition number 1, bona fide purchaser for value. He must have purchased it for consideration and it must have been in writing. Number 2, he did not have any notice of B's interest. When those two conditions are fulfilled, then he will be ranked far and above B's interest. But for those two conditions being fulfilled, he would not. Do you understand that? So now we've understood it from the common law perspective. We've understood it from the English law perspective. Now let's come to Nigeria. Is that the same thing when we are talking about customary law in Nigeria? Do we still look for the requirement of bona fide purchaser for value and without notice of the equitable interest? If that is the case, are there other things that we are supposed to look at? If that is not the case, then what exactly is the case in relation to the customary law and equitable interest in relation to purchase of land in Nigeria? That's what I'll be talking about in my next class. Thank you so much for watching to the end of the lecture. Make sure that you subscribe, like, and share this lecture video with your friends. My next lecture would be how to identify equitable interest, purchase of land, part 2 in the Nigerian context. I will see you in my next class.